Thank you. Thank you for that really innovative and very timely proposal. Thank you. Our last speaker is presenting on Skype again, and it's Professor Sujayadi from Indonesia.
His Honorable Chairman of the panel, ladies and gentlemen, and my dear colleagues, good afternoon. It is an honor for me to speak before you in this excellent and inspiring conference to share many ideas concerning sustainable companies issues, even though I couldn't come to Oslo to attend the conference because of administrative matter. However, I believe that it is not a really matter today because I still can deliver my ideas in the virtue of information technology. First of all, I would like to convey my honor to the organizing committee of this conference from University of Oslo, especially Professor Beate Schaafjell and my dear Professor Tineke Lamboy from Utrecht University School of Law, who give me an opportunity to share our ideas and experience concerning CSR in Indonesia. Ladies and gentlemen, I would like to deliver my ideas in briefly, and I promise to keep it short about the law enforcement on CSR in Indonesia. As a developing country in Southeast Asia, Indonesia has an abundant natural resources that is exploited by many corporations today. It means that Indonesia facing a risk of environment damages and of course social conflict between companies and the communities. The government as well as the lawmakers look into the potency of CSR to be an instrument to minimize such risks. Therefore, in 2007, the Indonesian lawmakers enacted Investment Act and Limited Liability Company Act, which integrating CSR companies as companies' legal obligation. Two issues I will discuss in this forum are: what is the nature of CSR provision in Investment and Limited Liability Company Act in Indonesia? And the second, what kind of law enforcement if there is any violations against such provision? Ladies and gentlemen, I would like to address the first issue. CSR in Investment Act is set out in the Article 15b, in which it provides that every investor shall have obligation to implement corporate social responsibility. I give emphasis on the use of word shall, in which it has a meaning that the provision is a mandatory obligation for the investors. However, the Investment Act is quiet on the sanction when the investor do not comply with such obligation. Then, in Limited Liability Act, the CSR provision mainly provided in Article 74, paragraph 1, in which it provides that companies doing business in the field of and or in relation to natural resources must put into practice environmental and social responsibility. The use word must implicates that the provision is a mandatory legal obligation. Soon after the enactment of Limited Liability Company Act, some people, among others is Indonesian Chamber of Commerce, who think that CSR should not be regulated in the Limited Liability Company Act, filed a challenge to the Constitutional Court, asserted that CSR is not a legal obligation. However, the Constitutional Court in its final judgment confirms that CSR is a legal obligation and it is in accordance to the Indonesian constitutional law. Then the debate goes into what kind of sanction that can be imposed to the companies which do not comply with CSR obligation. Unfortunately, ladies and gentlemen, the provision regarding the sanctions to the companies which do not comply with CSR obligation as provided in the government regulation is unclear. The common interpretation in here is that the company should be sanctioned in accordance to the law in which the company may violate. For example, if there is a company in its operation may result chemical substances and pollute the river, then the company must be sanctioned in accordance to the environmental law. However, such interpretation cannot answer what the sanction can be imposed to the company which doesn't have CSR program in its operation, while it is its legal obligation. Such interpretation may also negate the intention of the lawmakers to bring CSR from moral obligation to legal obligation by framing CSR into statutory law. Ladies and gentlemen, some of you may think that my point of view is too positivism. Some of you may think that my point of view is too conservative, and I believe that some of you may think that my point of view is an old-fashioned in the legal doctrine. However, ladies and gentlemen, the Indonesian lawmakers have dragged CSR as moral obligation into legal obligation by framing it to the statutory codification, and there should be legal consequences. Once it is framed as a legal obligation, the law enforcement agency should make sure that the law shall be obeyed. Law always comes along with sanctions. It is a coercive power to make sure the obedience of the people toward the law. Then, if the nature of the CSR provision in Indonesia is a legal obligation, how it should be enforced? Ladies and gentlemen, I would like to address the second issue. Indonesian Investment Act and Indonesian Limited Liability Company Act do not provide specifically the sanction against company which doesn't comply to its CSR obligation. Indonesian legal system, which derived from Dutch civil law system, recognizes unlawful act as part of the law of obligation. It may equal to tort in common law system. According to the Indonesian legal doctrine, an unlawful act is any act, whether it is active or passive, which is contrary to the legal obligation of someone whom imposed such obligation, or contrary to the good moral and social conscience. Therefore, the legal doctrine sets at least 5 elements to be proved before the court so someone can be sued on the ground of unlawful act. I have mentioned the elements in my paper. Ladies and gentlemen, companies who do not put into practice its CSR obligation may be sued on the ground that the companies have committed an unlawful act. The company disobeys its legal obligation set on the statutory law and may make any damages, whether actual losses or potential losses, against environment or society. Then the question goes into who has legal standing to sue the company. In my best legal consideration, in accordance to the Indonesian Code of Civil Procedure, I propose the state's attorney as the representative of the state in civil proceeding, representatives of the community in class action procedure, or non-governmental organization. Those are who have legal standing in this matter. Ladies and gentlemen, such dispute may also be settled in mediation procedure. Indonesian civil procedure recognizes mandatory mediation in which the judges shall order the parties in the first hearing to take mediation lasted for 40 working days. For the foreign investor who refuses such obligation may bring the case to the International Arbitral Tribunal under Article 32, Paragraph 4 of Investment Act. Ladies and gentlemen, since reformation of 1999, Indonesia implements local autonomy principles in which the local governments are given wider authorities to manage their own local affairs. Then, some local governments also enacted local regulation concerning CSR, in which almost all local regulation concerning CSR are completed with administrative sanction if the companies do not comply with obligation. In conclusion, I would like to emphasize that once CSR is dragged from moral obligation into legal obligation, there must be consequences. The consequence is that the company must fulfill the obligation, and any violation against it, there should be law enforcement. Ladies and gentlemen, I am really sorry that I cannot be involved in the panel debate, but if you have any question regarding my presentation, please contact me by email. Thank you.